I hereby consent to consent to follow the terms and conditions of a specific website. And also there was something concept of general consent. I agree to all the terms and conditions. I agree that this website will take up my personal data and store it somewhere. So that is how it was done. And every website had its own type of notice, and there was no uniformity in it. I mean, and nobody had the time or the knowledge to go into the terms and conditions. Usually in very small print, you can't even read the font. You just click OK, assuming that, okay, some terms and conditions have been thrown at you. You just accept it and move on. Now, this is the reason why, if you notice, in the last 10 years, many data misuse. I think you must have heard various stories of Twitter using data of people in the back end. There was a lot of, in fact, sovereign governments fight with Google, fight with Microsoft, and also India's fight with Twitter. I mean, it's all a lot of stories. You must have heard it. And that is because there was no concept of a common law to control how personal data is taken up by these companies, and how they are used, and how they are transferred to somebody else, or even sold. So there was no control. So this DPDP Act 2023 essentially is meant to solve that problem. Okay. So that means there have been the apps already have those notices. They already have pop-ups which take your consent before you sign up into any web application. All that is already there. So what is new in this act then? Yeah, the new in this act is that the consent has to be taken as per a specific procedure. That is the newness of this act. So the consent notice has to be written in a specific way. The consent has to be sought in a specific way. The data which is taken from the end customer has to be used in a specific way, stored in a specific way. And also, the other important aspect is the last 3 points mentioned in the slide. That is facility for withdrawal of consent. In fact, this is one of the biggest issues in today's e-world, internet world. You can gladly give your subscriber data to any website. That every website takes it, but you can hardly find out by looking at the plain look at the website from where, how will I withdraw my data from a website? How do I unsubscribe? Subscription is available. Unsubscription is there in a few websites. It is there, but by and large, you can't even find a provision in the website where I can withdraw it. And second, one more thing is, okay, every day I'm bombarded with hundreds of new apps, and everywhere I go, it asks me to enter my name, user ID, password, address, PIN number. And how do I keep track of it? Nobody keeps track of it. Nobody knows how many apps we have subscribed in the past. So that provision also is going to come into the new law. So that is reason why we need DPDP Act. So what is digital personal data protection? So like I said before, the data what you give to a website must be processed with consent. Consent should be taken before it is used, and the consent should be obtained for exactly what it is going to be used for, and nothing else. And once the purpose, that's why we call the specific purpose. I think the Personal Data Protection Act talks about a concept called specific purpose. You cannot use general purpose words. Like in your notice, you cannot tell the user that, okay, please give me your name and number. I hereby consent to giving my name and number. I mean, that is not good enough. You have to tell exactly for what you are asking that information for. So if you are saying that I am going to use it for processing a visa, then you say that I am going to use it for processing a visa. So that means that purpose should be, the data should be kept with the company which took your data only till the purpose is solved. After that, they cannot retain the data unless the consent says that I'm going to keep your data forever. Because for next year, after you, like for example, if you go to a Pizza Hut and order pizza, they ask for your name and phone number and address, and they come and deliver a pizza. And then after 1 year, you get a happy birthday greeting from Pizza Hut saying that happy birthday to you. So why are they sending a birthday greeting after 1 year for me having purchased one pizza on one day? So this means that they are retaining my data, right? So this retention of data unauthorized in an unauthorized manner for some other purpose, like sending happy birthday or probably selling some other goods to you, is not permitted. So if I have given my phone number for a specific purpose for delivery of some Zomato food, only for that purpose that information should be used. They cannot use it for something else. So this is the key principles of digital data protection. So, and second is this framework creates rights for the data provider. The data principal, they call it. Under this act, a person who uses a website is called data principal, and the company who takes your data is called a data fiduciary, and a person who manages consent is called as a consent manager. So these are some of the legal terms which have been introduced under this act. So a person who provides the data, personal data, is called a data principal, and their rights have been enshrined in this act. So those individuals have the right to access their data consent. They are right to correct the consent. Correct means, okay, I gave consent for 10 applications. Now I don't want to give. I only want to give it for 5. The other 5 I want to stop. So that also you can do. Erase it, withdraw. I don't want any my consent towards any of your applications. The end. So don't, you take away my data, remove my data, erase it. So that rights also I have. And other thing is for children. For example, if a child has to be, enrolled in, say, an IIT JEE like Allen or one of those online coaching institutes, then the child cannot consent, the parent has to consent. So you have to nominate somebody else to represent yourself for the consent. And also the last part is the grievance redressal. Today, frankly speaking, the only approach for anybody, any of these activities, you have to go to the cybercrime police. There is a police station where you can go and file the FIR. And frankly speaking, the cyber police, even though they have knowledge about Information Technology Act, they really don't know what action to take. Even websites do which host your sign up. Suppose you want to get unlist yourself from those websites. Police has no powers. They have no reach also. So under this act, then there is a tribunal, there is an appellate tribunal, and then subsequently Supreme Court is also there. So the matters can be taken up with the Data Protection Board of India on a complaint by any user on misuse of data or leakage of data, and then that matter will be taken up like any other investigation. So, and then appropriate remedies can be taken. So, what is personal data? So, this is the next part which many of us must understand. So, any information which identifies a person or it is identifiable to a person. When I say person, only natural person. Please remember that this act was created in consequence of the landmark verdict Justice K.S. Puttaswamy versus Union of India case. So this is about right to privacy, which is now declared as a fundamental right. So fundamental right is attributable only to human beings, to natural persons, not to legal persons. So this information, what we are talking about in this act, is only related to information which can be connected to an individual, not to a company. So a company PAN card or a company's SIN number, if it is given to somebody and that gets used somewhere, that is not included in this act. It is only information which is connected to a person. So therefore, your name, email, address, photo, your PAN card, Aadhaar, biometric data, your bank statement, IP addresses of your computers, those are only covered. And this applies to only the data collected within India, and also any data which is processed abroad, outside of India, but in connection with delivery of goods or services inside India, or any transaction of goods and services inside India. So if you have a website like Amazon.com, means Amazon.com is a US website. India is Amazon.in. So if Amazon.com collects data and supplies the goods to India, then whatever data you give to Amazon.com US, they have to comply with this law. But if somebody is sitting in Europe, purchasing from Amazon.com, obviously this will not come because it's outside our territory. And so what kind of data, right? See, this is where the confusion comes in. Many people have this confusion that, okay, I go to some trade show And as soon as I enter in the registration counter, they ask me to give your visiting card. And they ask you to drop the visiting card into one bottle. Is this covered under DPDP Act? Because I am giving my personal information. So please note that DPDP Act is applicable only to information that is found in digital form, given in digital form. That is, whatever information you give in digital form means through a digital channel you supply it. You enter your name and phone number in WhatsApp or email or some form, a website form in some website, or a sign up form in some web application or mobile app. That is covered. Or if you are giving a piece of paper, like you must go to if you go to a college for admission, they ask you to submit your 10th marks card, 12th marks card. But usually you give photocopies, right? And if that photocopy is subsequently digitized by the college and uploaded into some ERP or some other Google Drive or something, then it's applicable. So the person receiving this data, if he digitizes it, it is applicable. If he doesn't digitize it, then this act is not applicable. So if you keep paper copies, live in paper copies and die in paper copies, not applicable. So, and second is, I'm sure people will give each other everything. Like you meet a friend in some cafe coffee day and give your phone number to him. Now, do I have to sign a consent up for this? No. So that is exclusions are when it is processed for personal or domestic purposes. Then it is not applicable. Only for the purpose of business, commercial purposes, this data is collected, then only this law act is applicable. And who should provide consent? The person giving the data, whose personal data is it all about. Like if it is my name, my address, my PAN number, then I have to give consent. Nobody else can give consent except when it is a child or a person with unsound mind. So if a person with unsound mind or child, the guardian can or a parent can give the consent on their behalf till they become the age of majority. After the age of majority, the person only has to give the consent. And please also understand that under this law, you cannot grant power of attorney for to anybody. And also, please, one of the notes at the bottom I mentioned is about that this personal data is only to be identified to an individual. So at the moment, if it is related to some HUF or AOP or a company, it's not included. Okay. And this is what I was mentioning about the rights of personal data holders. So everybody who is providing this data, such data, they have the right to provide the consent, withdraw the consent at any time. They have the right to access their consent records. So this is, I will talk about this impact of this law on IT companies, businesses in India, etc. subsequently. But broadly, this gives you a general idea about how this is going to impact your business. And the other thing is about correcting or amending your consent. Like I said, you might have consented to Zomato saying, okay, deliver me some food item for once. So therefore, subsequently, if Zomato uses it to deliver something else without your consent, it's not allowed. Then right to remove, I already mentioned, right to grievance redressal. See, these are the two important aspects. That is the accessing consent records and right to grievance redressal are going to be. So which means right to grievance redressal means what? Which means that any website where you go and sign up for an application like Google or email or anything must give a form or a URL where I can click and complain saying that my data I'm asking to be unsubscribed. It's not happening. Please unsubscribe me. Or I got some promotional marketing material from Google or whatever the company is, but I had expressly told not to send promotional materials. Please stop sending promotional materials. So that grievance has to be addressed. If they don't address it, then this can be filed as a complaint before the Data Protection Board of India. And then what do you mean by consent? Consent, like I said, is not general consent. This is what was happening till today. Before DPDP Act, consent was general. They will have a sign-up screen, and then they will say, do you consent to giving me all this data? Yes. And you press yes. For what? Nobody knows. So you give it, and then later that data is used for sending happy birthday, for, and then all unrelated marketing material starts coming to you. So maybe they have sold the data to somebody else. That also we don't know. I'm not saying they are doing it, but you never know. So that means that the consent under this act, consent means when I say, okay, please use my data, it has to be informed. Must be informed means, what do you mean by informed? So if you notice, 99% of the apps today, web apps or mobile apps, all are in English. They are not provided in native languages. Under this act, any notice provided by any website operating out of India must come in 22 languages. So if you want to see the notice in Kannada, there should be a URL there. I select the language and the notice should appear in my language. So this is one change which I think most vendors who are providing these platforms may not have been aware of that. And then second is, it should be specific. Like if you say that I am using your address for delivering a parcel, that means that information, that whatever consent you obtained can be used only for delivering the parcel, not for doing something else. Like happy birthday greetings cannot be sent, because I didn't give permission to send me happy birthday greetings. If you want to send happy birthday greeting, you have to send a consent request to the end user asking him, I'm going to send happy birthday to you, are you okay? Then only it can be sent. So then once the purpose is served, the consent is automatically withdrawn. So completion of purpose is an implied withdrawal of consent under this act. You don't have to specifically say I'm withdrawing. If the purpose is completed as per the notice, then it is. So that means your notice has to be carefully worded. If you want to retain the subscriber information for something else, like one of the very important examples I can give is, you go and buy some goods from some shop. So you have to give your delivery address. So they ask for the delivery address, I give, they deliver the goods. So after that, they have to delete my data. But can they delete the data? Suppose, let us assume that the contract of sale of goods includes a 90-day free return policy. Within 90 days, if you want to return, please send us an email. So if that is a contractual term, you cannot delete the customer record after the goods have been delivered, because for 90 days after that, you will have no trace of the customer, and when the customer wants to return it, he cannot return the goods. So therefore, it's very important that this purpose served means, what is the definition of end of purpose is dependent on the contract, and also how the legal notice of consent is sent to the end user. So if you want to keep it for 90 days, that data, till that 90-day expiry period, free return policy is ended, then in the notice you have to say that I am going to keep it with me for 90 days. If you have not returned the goods by 90 days, then your record will be removed. Then it is compliant to this act. And of course, the consent can be withdrawn by the data principals at any time, but subject to exceptions. Like for example, you take a loan from a bank and then you don't repay the loan. Now you cannot withdraw the consent and stop paying the loan and say that now the bank cannot inform some loan recovery agents about my address, because that is not allowed, because I have withdrawn my consent. No, because the consent can be withdrawn subject to whatever contract you have signed, subject to any law which is operational at that point in time. So, for example, banks under their banking law are allowed to approach and go to SurfAC for registering the debtors information. They are allowed to go to advocates for filing a debt, recovery of debt tribunal. Notice can be served on the person who did not pay the loan. So under that act. So there are so many other activities the bank does if you don't pay the loan. So here the debtors cannot use this DPDP Act to withdraw the consent to force the bank not to act on the individual. That's not possible, because that is allowed for the banks to act under the law. So anything operated by any other law, you cannot use the consent as a key to stop the other person from acting. So that's another point. And then, like I said, data fiduciaries, that is the company which took your data, can only use the data for the required purpose and not for any other purpose. And another point I was mentioning here is about so can I appoint somebody to act on my behalf for managing the consent? Answer is no, because fundamental rights, right to consent, is a personal right. And as far as current law framework in India is concerned, you cannot transfer personal rights by doing power of attorney. You can appoint an agent. But agency is not a transfer of rights, but the agency is to act as an agent in representing you for a specific purpose. For example, in this case, under the Act itself, the data principals can appoint some content managers. So content managers can be appointed by the data principals to manage the consent. But they cannot press the consent button on behalf of the end user. That they cannot do. The consent button has to be pressed by the owner of the personal data only. Nobody else can act except for child and person of unsound mind or any court appointed guardian. Other than that, nobody else can provide the consent on somebody else's behalf. So therefore, that is one point here that you should notice, that if your business receives the consent data of an adult from somebody else, not the person whose data we are talking about. For example, let's say, school, of course, school up to 15, up to 18, all kids are minors. Let's say college admission. Let's assume for a college admission, after the kid has crossed 18, if the parents go and submit the 10th and 12th marks card on behalf of the kid who has turned 18, I mean, now he's no longer a kid, it's an adult. That is not permitted. That records have to be submitted only by the person, that student who's above the age of 18. So that is important to address here, that we are talking about agency to manage the consent and not agency for providing the consent itself. And what is a data fiduciary? Data fiduciary, I was referring to using the word company in all this time, because majority of the use cases of DPDP Act come with respect to a company which is hosting some IT platform or a cloud platform, and somebody using that platform for some service, email, WhatsApp, anything like that. But as per the DPDP Act, this is not a company to individual act at all. It is any person. Data fiduciary is any person. It can be an individual, it can be a company or a state entity. So it means, for example, one of the use cases we recently found out is some yoga instructor or some online coach who are offering services through WhatsApp. They have like thousands and thousands of subscribers, and they send the invite over WhatsApp to that person to come and join some webinar on a particular time. It is applicable to them also, because they are just people. I am just a person sitting at home offering some yoga services. So, but the thing is, it is for a commerce. It's not just a good morning message or some WhatsApp forward. It is a commercial request to come and attend some course for a fee or something. So in which case, it is a commercial service. So it could be any person. It could be an individual asking somebody to register on WhatsApp is also will be brought under this act. So that's the example I have given below. Like WhatsApp is also a digital platform. So if I send my phone number through or address through WhatsApp to somebody, before the address is, I asked for the address to somebody. I have to send a consent form. That person has to consent that, okay, use my address for some purpose, whatever purpose it is. The notice has to be issued through WhatsApp or through some separate channel. WhatsApp is a group, so everybody will be sitting on the group. So you don't want everybody's consent notice to appear there. That IT architecture is left to the company to do so. So they can privately send an email or something to that user to collect the consent before they say, please post the address. But here, please notice here that if I ask you for an address, then I have to ask you for a consent before I ask you for the address. But if that person voluntarily gives the address and phone number on the WhatsApp, no, take my phone number also, then this act is not applicable. So if you voluntarily give your information, it's up to you. I mean, whether I use it or not, that's a question that is a question which is like a gray line in this act. I'm not supposed to use it, but the fact that he has put his phone number in a channel, in a digital channel, doesn't automatically create a grievance for that person saying that, no, I disclosed my phone number in WhatsApp, so therefore the company which took my phone number is liable, or at least because I am voluntarily putting that number, that phone number or address in that platform. So it's I would say a gray area. I'm sure this kind of issues will come up in the tribunal in the years to come. Like, companies saying that I didn't ask for this information, he simply sent it, what am I supposed to do? Correct? If somebody suddenly sent, I asked for address, and he sends his entire family history to me through email, then what will I do? I cannot do anything as a company. I may not use it, but if you have sent it and it has fallen into the eyes and ears of somebody, what can they do, right? Those kind of issues will come up in future. And then, like I said earlier, that what are the duties of data fiduciary under this act? So the duties are that first you have to obtain a free, specific, informed, unambiguous consent. Consent has to be taken. The notice has to be in 22 languages, and also it should inform the clear purpose on where it is used, when it is used, how long it is going to be used, for what purpose it is going to be used. That has to be clearly mentioned in the notice. And the purpose, the usage is limited to that purpose only. If you use it for anything else, then so you might ask, like, how do I as a user know what the company is using my data for? So it all depends on the evidence. That's all. So you have to provide an evidence as to misuse. What way misuse? Very simple. If they send you a happy birthday greeting and you have not given consent for that, that is misuse. Because that is not the purpose for which you gave your number for receiving happy birthday notification. So you now companies, that means if you are running a company and you have decided to send a happy birthday to your customers, you have to think twice. Because before sending that, you have to get a consent from your customer saying that I am going to send a happy birthday. Then take a consent, then send a happy birthday. You cannot send a happy birthday and expect that, okay, it's a very, feel good message. What is so funny after all? What is so greatly, offensive to the end user like this? No, not necessary. Under this act, even happy birthday messages can turn out to be a illegal act. So you have to be very careful about how you use the data of customers. Okay. And so this is the issue I talked about, that deletion of data once the purpose is fulfilled. So what is purpose? So you should include the contractual obligation between you and your customer to determine the end of the purpose. So like if you add warranty period also into that, then you should keep your customer data till warranty period, because you offered a warranty and you tell that I'm going to offer you warranty for 1 year. So that 1 year you will keep the data. But that has to be informed in the notice. You should put in the notice saying that this is a product I am delivering with a 1 year warranty. Then for 1 year you can keep the data. So therefore you are informing the customer that your data will be with me till end of warranty. And warranty ends, it stops. And exemptions are there, of course, like every other act, it will all have hundreds of exemptions, but here also there are exemptions. So under constitutional provisions of fundamental rights, there are a set of exemptions, which is like, national security, sovereignty of India, protection of the borders of India, territorial integrity, etc. That's standard constitutional parlance. So those are also included as exemptions. Legal and investigation professionals. That is, if I give the data to an advocate to file a case against me for recovery of dues, that will not constitute illegal disclosure, because it's in for the purpose of legal and investigation procedures as allowed by law. Publicly available data. Like for example, if you can prove that the end user has published this information in a public forum and it is visible to me without user ID and password, then it is not come under the act. Like for example, there are these motivational speakers, correct? They go all over the place. They put their profile in LinkedIn, in Instagram, everywhere with their phone number, everything. So I have put my phone number and my profile in Instagram. Later I cannot claim that you have used it without consent, because somebody telemarketing fellow can take that phone number and call you. But that will not fall outside this. I mean, you won't attract any liability under this act, because it's a publicly available data. So if a person complains saying that somebody misused my data, my mobile number which I put on Instagram, the other person can come to the tribunal and say that, look, I took this data from Instagram and here is the URL from where I took it and his number was there. Then the person who complained will not have a cause to complain. Then personal and domestic use is another area which I think I covered earlier. So if I give it to my friend, then I don't have to complain, right? So that means for social purposes, if data is exchanged, then it won't get covered under this act. And then there are some things called legitimate uses. So these uses are again created under this act. Like if I voluntarily share data for a specific purpose, I go to a shop and I purchase a goods and I give my number for address to him and say, can you please give it to my house? That I gave the data address to him, right? So which means the consent is implied. See, when I give an address in a piece of paper to somebody, I've already consented because that's why I'm giving, right? So that is excluded. And then state roles, like, for example, you go and apply for a ration card or anything with the government, wherever any benefits is received from the state, consent is not applicable. So for example, you can get a message from Government of India for a scheme which you did not apply for, which you never went into some website and clicked on some sign up button, but you can still receive that message. Like state will say, look, your PF, some 10% subsidy is going to come next month, please apply. That is excluded from this because for distribution of benefits to citizens, and they can't take consent from everyone, right? So it's not possible. And the whole idea is many people are not aware of the subsidies. So if you prevent the government from sending emails or WhatsApp messages, then that subsidy will never reach the ears and eyes of the common man. So that's excluded. Medical emergencies. So somebody arrives in the hospital in an unconscious state. You cannot take his consent before using his name, number, etc. So medical emergencies excluded. Then employment related purposes, like you give you seek employment with a company, then the company will call some training person to come and train the employee. They will share the employee data. So for everything, the employers cannot be expected to ask the employee's consent. So therefore, employee information, where employees' information is collected by employers, is excluded. But it again here there is some, I'm sure there is some gray lines, which probably will be tested in the court in the years to come, which is what if the employer takes the employee data and sells it to some insurance company for selling insurance to the employees. It is possible. So I think I get a feeling this, you cannot use a very, umbrella permission given by the act and then apply it to all scenarios. I am sure that court will probably rewrite the interpretation as soon as these cases start coming up. And then research and archiving, they have given some exemption for where you use it for statistical purposes and directly don't use it. I mean, if you use the data of the individual directly, it's not allowed. But if you collect, for example, the income level of all people living in JP Nagar or in South Bangalore, yeah, you can do it. You can collect the income from somebody else. But no, the individual, it should not be connected to the individual. As long as it is not connected to the individual and not recoverable from the digital system as an income of a specific individual, it's okay. Then government notifications, like I said. So penalties under DPDP Act, something to worry about. The numbers are quite huge, but luckily for the law is written stating that it is up to that amount. It says up to 200 crores, up to 50 crores. So I don't think a company whose turnover is 1 crore will receive a 50 crore penalty. I doubt it. But there is no data as of today as to how many people have gotten penalty notices for what amount is not there because this act is still going to happen in the next coming months. So we'll probably hold off on that. But the thing is, big companies, I think this act has got a serious target on what they call under this act as significant data fiduciaries, which means companies like Amazon, companies like Microsoft, Google, I think who are holding like billions of people's information. I think it is for them, we are talking about this number for 250 crores, 200 crores. It may not be a big amount for them, but that is what this is meant to be. Then I talked about, what do we do for a data principle under DPDP Act? If they have any problem, what should they do? They have to first go to the internal grievance redressal. That means the portal or the web application which is providing the service, they themselves have to provide a small form saying that, okay, I have this problem, somebody leaked my data, please complain here. So that has to be provided. That is the first step. If the portal itself does not have such a facility, there itself comes the first penalty under this act. So directly the user can complain to the Data Protection of India saying that your website does not have this information, to this form for grievance, and there itself your notice will be served onto the company. Then escalation to the DPBI is the next step. After internal grievance cannot be settled, next step is the first authority is Data Protection Board. Subsequently, appellate tribunal is actually for Telecom Dispute Settlement and Appellate Tribunal. TDSAT is been given the authority to act as a appellate tribunal under this act. Then after that goes the final appeal, go to the Supreme Court. So there is no route via the High Court. It goes to the appellate tribunal and from there directly to Supreme Court. And then there are, of course, under the data principals can exercise their right to correct, withdraw the consent, etc. All those stuff. So now comes to an interesting point. There are hundreds and hundreds of use cases where somebody is picking somebody's personal data in the world, right? So how do I know which falls under DPD Act, which one doesn't fall under DPDP Act? So actually speaking, we don't know. We can't say it for sure right now, but I have picked some few use cases here, like a trade show collecting visiting cards of people. Actually, they don't have to comply to this act. But if they scan the visiting card into a CRM, then they have to comply. Second, the college is collecting student 10th and 12th mark sheet photocopies. The photocopy you can collect without complying to the act. But if they scan the mark sheet and upload to a Google Drive or an IT app, then yes, they have to do it. A real estate is connecting people to clients, real estate agent. If it is directly, he is calling that person saying, okay, sir, I will connect you to this client, then it is not required. But if there is a business, under this business use, the real estate agent shares this data with somebody else, or he has a website where he has to ask the people to register, then they have to comply. So any website which asks a customer to fill a form with name and address and phone number, directly they will have to comply. Because any digitized information, you have to comply. Then online instructor doing business over WhatsApp, or a housewife selling sari over WhatsApp, it is a commercial operation. And if they are sending address and phone numbers over WhatsApp, they have to comply. Because it's a commercial operation. It's a selling of saris or doing online instruction of yoga or some exercise. So all those people have to comply. Then simple rules to check is, are you receiving personal data for business or personal purpose? Are you receiving it in paper or via some IT app? If you receive via email also, it is digitized form only. So directly you will fall into WhatsApp. It will fall into digital. If you receive only on paper, then only it will not fall under this act. Are you delivering a service within India or outside India? That is another simple rule you have to check. And are you falling under any exemptions under the act? So these are some of the simple rules. If you do it, then you will determine your compliance to the DPDP Act. Now, do you know, can you do this check yourself? You can do it 80% of the time, but 20% of the time, the use cases are very complex, where it involves multiple stakeholders. Then in that case, you can seek some help. That's the only way to do it. And another important aspect in this law is there is something called as a data protection officer. So data protection officer, do you need to appoint one under the act? Because there is a provision for appointment of DPO by an act. So does it mean if I am running a small medium business, immediately I have to appoint a DPO? No, not mandatory. So only under certain conditions, where if you are a significant data fiduciary which is notified by the government, then you have to do it. Or your activities fall under such things. Like if you are into CCTV surveillance, geolocation tracking is done by your app, you are into advertising, some specific set of activities, we'll have to check you have to go through the rules and your company to understand what is that exactly you're doing with the data, based on which you will be, you can be advised, whether you should have a data protection officer appointed or not. For small SMEs, you don't have to appoint a data protection officer. But just to be sure, to avoid any liability, you can have somebody appointed as a virtual officer for the purpose of just giving some guidance. If it is required, you can do it, but it is optional. And what is the timeline is, luckily it is not tomorrow. You still have another 57 weeks, which is May 13th, 2027 is the deadline. But we think why are we having this call today? Why are we having this webinar today when it is 1 year from henceforth? For that, we will have to go to the next set of slides. This is the list of things you have to get done before you can call yourself as compliant. So this is a lot of work to do. I mean, it might look like a simple set of things to do, but it is a lot of work to do. It will at least take a few months to do this. So if you start in April next year, you may not finish in time. So therefore, we are coming now and saying that please get ready for doing all these things. You can put a calendar to do these things, but this needs to be calendarized, and you need to get an opinion. First of all, you need to, if you are running a business, you need to understand whether you are going to need to comply to this act or not. Itself is a question, right? So that you need to get an opinion. Then you need to inventorize your apps, what you are serving your company, your customer. How are you collecting customer data, in what format? All those things you have to do it and inventorize your business process. Then if you already have an app, I'm sure most of you will have an app to deliver these things to the customer. Then any change, you need to change those apps to comply with this, or introduce one consent management platform through which you can manage your consent records. Because your consent records can be kept integrated into your existing app, but under this new act, because you have to allow the end user to see his consent records. The end user has to see, able to see what all things I have consented in the past, since the last 2 years, 3 years, 5 years. Then that person should be able to log into your app and ask you to show me the list of consents I have given. So for that, definitely you need a database and a kind of a platform which will track all the consents against a user ID, against a mobile number or an email ID. So that implementation also you have to do. So, and then legal changes. Here, another important part, which I think maybe in the subsequent webinars I can take, but today I'll just quickly touch upon, is data processors. Suppose you are outsourcing your operations to somebody else, like for example, Wipro or Infosys, they outsource their visa operations to another company. So you have to transmit all your employee data to that company. Does it mean data processor also will come under this act? No. Whoever touches the end consumer only has to comply. If I outsource, he is not touching your customer. He is only touching you. But having said that, if data processor leaks any data, the company which outsourced that information to the other company will become liable under the act. So therefore, you should have very strong contracts. The contract between you and the outsourced vendor should be very clear, and should also and you should also have some kind of liability clause saying that if I get liable, then because of you, then you have to pay for the compensation. That liability clauses have to be added. So there will be some changes in your agreements. And all the previous business which you have been doing, you might have some 1 million customers as of today, and you would not have the consent records for the last 10 years of operations. All those consent records also you have to bring on board. So you have to send consent notices to every existing user, collect the consent and store it in the database. Then you may have to appoint a VDP or a DPO as if applicable. And also you need to migrate to the new scheme and the approach of handling the consent. This consent can no longer be simply some few clicking buttons. You have to show the notice in 22 languages. You have to do some IT changes have to be done in your web applications also. So that's why it is important that you start maybe today or maybe in the next few months. And yeah, I think pretty much I think that is the the end of my PPT. Sujata, I think you have anything to say? You can proceed.
Yeah. Thank you so much for your insightful presentation, sir. Now the floor is open for question and answers. I can see some of the questions put in the chat box, my chat box. So I would like to, I want you to answer that. Okay. One is that what happens, I understand that this act is coming into force in a phased manner from 2027. Having said that, what happens to the data or my private information that I have given to my, as a data principal, I would have shared certain information, my personal data to data fiduciary. So what is the applicability of this act for the past data?
Yeah, see, as soon as the notifications arrive, you become liable for all the past data also. That is why this act is going to come into force only from next year, May 13th, 2027. So therefore, you have sufficient time to migrate all your previous end users and take consent for whatever you have taken consent in the old format. So you must have taken consent in some format, but that format has to be replaced with the new format. Plus, like I said, you have to store a consent record. Every consent is a record. It's a legal record. Remember that the consent is a legal record. Because tomorrow, if your end user goes to Data Protection Board and files a complaint against you, the evidence which will help you defend your case is only the consent record. So you have to maintain it in a separate database. So preferably that consent management system or whatever needs to be installed, and only from that you will be able to pull out all the consent records with respect to a specific complaint or grievance or whatever.
Yeah. So another question which has come to me is that basically we hire car drivers and domestic helpers. In such cases also we do collect their PAN and their Aadhaar or personal information. So for if I employ anybody for my domestic need, am I liable to comply under this act?
Yeah, so that's very clear. It's not there. Personal domestic is not there. There is a gray line between when domestic purpose will turn into a commercial purpose, right? So, like for example, like I mentioned in one of the previous slides,
This is a commercial.
you go to an apartment, there are housewives who are delivering food via WhatsApp, or they sell saris to each other via WhatsApp within the community. Are they commercial or are they domestic?
Commercial.
This question, I think, I'm sure it will come to the tribunals a lot more times. I think eventually it will get clarified. But my personal opinion right now is that any furtherance of business, I mean, it's just like how GST Act views goods and services, the transactions of goods and services. So anything with relation to delivery of goods and services for a consideration in furtherance of business, I think that will be the definition under which whether we will classify it as domestic or commercial.
I think every service is a commercial activity finally, because there is some consideration is there, no? When you are using the data.
Yeah, but there is something called, business establishment, and another thing, the test is doctrines are there even in Income Tax Act, I think, where there should be some repetitiveness in your service. Like if I sell somebody one idli for the last 3 years for 10 rupees, that will not fall under commercial. But if I give a menu and say my idlis are 10 rupees and every day I supply idli to multiple people, then the test of business establishment will
Commercial.
pass. I think maybe Sujata, you can also tell. I think this could fall under some of these taxation statutes also, right? How do they determine?
As far as the commercial intent is that what the underlying fact here. So when I'm not a business owner, I'm employing some maid or driver only for my personal use. If that being the case, in my limited understanding and my humble view, I don't think this act is applicable. Second is that if we collect only in digital form, this act is going to be applicable. Otherwise, not.
Yes, yeah. So if you are collecting on photocopy of Aadhaar card from your
copy of Aadhaar card or PAN card in a physical format, this act is not going to be applicable. Can I understand it that way?
Yes, that is to be safe, I am saying. But I think there are multiple rules, especially in case of domestic. Like I said, you need to fall under the definition of a furtherance of business. So that means that I am offering that service somewhere in some forum, and also I am repetitively offering that goods or services to many such people. One transaction somewhere for consideration will not fall into this act.
Can I ask one or two questions? No?
Yeah.
Huh?
Sir, there are in the chat box, there are many questions. I request him to answer one by one.
Yeah. Can I ask?
Yes, sir. You are free to ask. Yes, sir.
Yeah. See, a lot of exclusions are there. And one of the main exclusions is government of Karnataka, government of India and all. With all that, how far this act will be successful? Number one. And secondly, how to trace when we give a data to one of the agencies, how do we know that they have shared or they have shared with some other agency, and we don't have any track to know who has really shared the data?
Yeah, I mean, see this question, I think it will only come subsequent to an allegation made by somebody. So somebody has to do an investigation. Now,
that's not a.
there is I mean, if you don't have. The same issue is there even in Competition Act, right? Somebody is monopolizing the industry, a vendor. Very limited evidence is available with anyone to accuse a company of monopolizing the act. Same will happen here also. This is also same thing. See, this issue, DPDP Act itself, is came about because of very large companies. I don't think it is because of some small shopkeeper who was sitting next to you. I don't think that is the genesis of this act itself. Same way how Competition Act is only dealing with significant big with companies with more than 40% market share in the market. Similarly, here also,
Yeah, but
significant data
yeah,
fiduciary is the biggest concern for DPD Act. Now, an SME can also do the same thing, but producing evidence definitely is a difficult activity. Like I think in the beginning of my meeting, I mentioned one use case. Like, for example, you receive an happy birthday notification from your company. That is itself is illegal. They cannot send you happy birthday greetings without asking your consent. So,
yeah, that also leads to, that means now digital marketing will have some issues because
yes,
every digital marketing persons, they do this. They
correct.
send greetings, they send wishes. Yeah, I mean, involuntarily, they also ask, whether we are interested in that product. So all these things will stop.
You have to stop, exactly. So, suppose I went and purchased a product and
Yeah.
I got a message from them saying, are you interested in some other product? That is
Mhm.
illegal. Unless they ask me first saying, are you interested in receiving promotional material for any other goods or services offered by our company? And I have to say yes, then they can send.
Yeah. And secondly, with the AI coming up,
Mm.
how some of the data maybe we are not intentionally shared, but that becomes a part of the AI.
Yeah, exactly. See, if you look at AI, will fall under data processor. Like for example, they share your income data into an AI agent and ask the AI agent to process your data and say that, okay, look whether this person should be given loan or not. So I
Yeah.
have gone and asked ChatGPT this question by uploading all your last year's bank statement into ChatGPT. Now,
Yeah.
under the new act, it is not permitted because there is no way you can sign a contract of non-disclosure with ChatGPT, right?
Exactly.
But ChatGPT is a subscribed service. But if it is a contractor, you can. That is allowed
Yeah.
under this act. Data processor can process the data, but you should have a contractual condition saying that if there is a disclosure or leak, then data processor is held liable, or that level of security and safeguard should be provided.
Yeah. And similarly, if data is provided in a not in a digital form,
Mm.
but the agency takes it into a digital form, we are not responsible for that because we have given it in a paper form. Then how do they interpret that?
Exactly. Like I said earlier, like you go to a trade show, you give your visiting card, you
Uh,
drop the visiting card in that bottle which is kept in the
yeah.
reception.
Yeah.
You will not know whether they digitized it or not. How will I know, right? Now,
Yeah.
but tomorrow, yeah, at the end of the trade show, they will send you one message. Email will come to you. Thanks for attending this trade show. One message will come.
Yeah.
That is illegal.
Yeah.
That is illegal.
No, how? No, they have not digitized, but they have entered only. They've collected the information. Must have stored in a manual form, and they have sent
No, this
kind
is
of a,
manual. See, digitized means doesn't mean scanning.
yeah.
Digitized means you have stored the
Yes.
data about a person in a digital form in a digital platform. That's all. So if I enter your mobile number into one Excel sheet in Google Drive, that's all. That means you
Mhm.
are digitized it. That is digitization. Digitization does not mean scanning manual documents.
No, no, scanning. Even they may not even put it in Excel, etc. They might even a manual form also they can keep it. No, one more important question is when we heard someone else saying that we use apartment data. Okay.
Correct.
So in that we use our own WhatsApp forums
Mm.
with the management like MC etc. We have created a WhatsApp platform. See, most of the people don't see their mails. So to facilitate interactions and discussions, we have created this WhatsApp forum. So
Correct.
does it come under this?
No. That's why I'm saying you have to provide a business over that WhatsApp. Providing a WhatsApp, it's a digital forum itself, it doesn't fall under this act. But if you
Yeah.
start collecting information through, like you cannot send a message to a so and so apartment number, so and so. Can you please tell me whether you have paid your maintenance last month? You cannot send such messages onto that WhatsApp. If you do
That's
that,
not possible.
then you will
No.
fall into this act.
No, but that's being used now in most of the complexes. They use all such information through WhatsApp only, and in
No,
fact, a
there is
lot
no
of
information.
interactions takes place.
See, general information, like what does an apartment owners association do is to
Hmm.
collect maintenance from the end users. So through
Yeah.
apartment data, you are giving that information and you are asking for the name and number of that person. So the apartment data should have a consent form. They should definitely,
Ah.
before registering in an apartment data, you should have a consent form. Now,
Hmm.
if you take that information, put an Excel sheet, let's say classic example is in the WhatsApp group, you will find that people, association members sending an Excel sheet of people who have not paid the dues.
Correct.
That is a
Yeah.
personal data. That is personal data. Now you cannot send it like that into WhatsApp groups. You have to think twice.
Yeah.
So you have to take the consent.
Individually
So what you have to do is very
consent.
simple. In the
Yeah.
beginning, when he registers for apartment data, you have to give a notice to him saying that your apartment dues, your apartment number, your name, your apartment dues will be published in WhatsApp at some point in future. I am hereby giving consent to use give the association the power to send such data in the WhatsApp. Like that, you have to take a specific consent. That's all.
Suppose the end user doesn't give consent, that means they're stuck.
Yeah, that's correct. So what you do is very simple. You say if they don't give consent, you don't, then the apartment data will not register. That's it, will exit. Then they will not get apartment data access. That's how you control. So you control saying that if you don't want apartment data, okay, don't, it's okay. Then you will not get access to apartment data also.
Yeah. Okay. Thank you. Thank you, Mr. Raghuram, for a very comprehensive presentation. Yeah.
Yeah.
Thank you.
Sujata, you want to, any other questions are there?
Anybody wants to have any questions? The floor is open. You want to read out from the chat box?
1 minute. I have to access 1 second.
Meanwhile, I have a question.
Can you
The
see the
tourist operator is collecting details of their passport and particulars of visit inside India. So does see whether this act is applicable to a tourist operator who's collecting foreign nationals' details, personal details?
Yeah. See, the definition of under this act is that if you are delivering any goods or services inside India, then in digital form you collect data, then it is applicable. So a foreign national in India giving his passport to a tourist operator is at goods and services delivered in India, then it is applicable.
But similarly, when we are applying for visa, etc., the tourist operator will collect this information. So first of all, he has to give a request saying that we are collecting this data. Do you have the consent, करके?
Yeah, the consent notice has to be sent. That's it.
So it is increasing the process actually. This.
Yeah, it is increasing the process. See, the thing is like this: if the industry was responsible enough, we don't need laws at all. No laws are required. So the laws come because somebody or the other is misusing it, and then everybody else pays the price for it. And eventually, business gets little. I mean, complexity of running a business become this week. I mean, this is against the concept of ease of business. So if you look at the government says we have ease of business, we are removing all unnecessary laws. But then we end up with this law because businesses have abused their powers of using the data.
We have to see how far this is successful in total.
No. See the success means, see, when the state uses its might to to come and with its crushing power on all these people to comply like this, I'm sure it will be successful. Because state at any point in time, when it starts enforcing its rules, it becomes difficult for people to avoid it or go run around it. It's only a question. I mean, the thing here is only thing is you can hide in numbers. Like people who commit petty crimes don't get caught by the police because police does not have time to catch petty crimes. But if it is a murder or a very aggressive crime, police instantly catches. So similarly here also, there will be hundreds of people who may be non-compliant. They can probably just like how the pickpocketers escape, they can also escape, no problem. But big people will get caught first. Like first step would be the big players.
Yeah. Okay.
Quick question. Can you hear me?
Yeah.
Yeah. So when we are dealing with companies for example, in Europe, they have something similar like GDPR, right?
Yes,
so
GDPR.
So sometimes when you're dealing with companies, they ask, okay, are you compliant with GDPR, for example? So are there organizations here in India who can sort of review your company and then maybe give you some sort of a certificate saying that, yes, you are complying with DPDP?
There is a provision for audit in DPDP. So companies are better off doing the internal audit of their processes and get a kind of an opinion like how internal audit is done today in finance and accounting, right? So similarly, you need to do a data audit. Because see, very small companies where the proprietor can see all his employees with his eye, this is not required, because they will just directly find out who's doing what. It only happens when the employees become invisible to the eyes of the board. So in companies which are like 500 people, 600 people, the CEO cannot fathom what an employee is doing in one corner of the building. In which case, you need an auditor. You need to go into every department and ask, okay, what apps are you doing? What kind of information are you collecting from customers? What emails are you sending? What are you asking your customers to send to you? Like the employee can get in and just send a message to the customer over email saying, can you please send me your PAN card? We can't find out, right? So these requires some process audits. So definitely it requires some once in a while, maybe once in 6 months or some internal audit, just to make sure that employees are following the SOPs as created in compliance with this act.
Okay, thank you.
Thank you so much for your wonderful presentation. With this, we are concluding the presentation. Thank you. Thank you all participants.